I'm a lawyer. Sorry, don't hold it against me. So I spend a lot of time thinking about bad behavior and mistakes. And in a way, my profession trades in the mistakes of others, whether it's from handling an acrimonious divorce or prosecuting a DUI. The mistakes fall on a spectrum, from honest to colossal. And intention matters, right? If someone bumps into you on the street and you fall over, you're going to feel a little bit differently about it than if that person intentionally walked over to you and pushed you over. Even though the experience for you there on the ground, it's pretty much the same either way. 17 years ago, I learned about a very particular category of mistakes within our criminal justice system, and it moved me so deeply that I went to the law school for the sole purpose of trying to prevent them. And this is the goal that sits at the heart of my work at Innocence Project Northwest. Now, a criminal conviction comes about a little something like this. First, a bad thing happens. Then law enforcement gets on board and they start to investigate and maybe come up with a suspect. And when they're done with that, they hand it all over to the prosecutors to decide whether or not criminal charges should be brought. If they are, then that suspect becomes a criminal defendant and they have the right to an attorney. And they also have a decision to make: to plead guilty or to go to trial and be judged by a jury of their peers. And if they go to trial and they're convicted, they have the right to an appeal. Sounds pretty good, right? It's thorough. And every stage of this process is governed by strict laws and procedural rules. Law enforcement must follow the facts wherever they may lead. The defendant enjoys the presumption of innocence. The defense attorney must zealously defend her client, and the prosecutor, who represents the state, must prove her case beyond a reasonable doubt and must seek justice, not just convictions. Now, every actor in this real-life human drama is either governed or protected by the Constitution of the United States of America and the Constitution of the state of Washington, and at the end of the day, justice is served. Right? Isn't it beautiful? I mean, what could possibly go wrong? Well, things do go wrong, horribly wrong. And in response to this, there's been a movement underway for the past 2 decades to try to figure out what's going on here. Nearly 70 organizations worldwide have been established, most of them in the United States, to try to identify and fix problems in the system. And we have learned something from the small number of cases that have been reviewed through the innocence movement. And I want to talk to you today about some of the things that we've learned. And some of it goes against sort of conventional wisdom about what we thought we knew about the criminal justice system. Now, the first lesson of the innocence movement is this: even under ideal procedural and investigative circumstances, with all the constitutional protections protected and respected, we convict entirely innocent people of horrific crimes that they did not commit. Nearly 100 years ago, in a court decision, a very famous jurist, a judge, we call him a jurist when we're lawyers, a very famous judge said, "The innocent man convicted is an unreal dream, a hypothetical rooted in fantasy, not a tragic reality." But today, thanks to the advent of DNA, we know to a scientific certainty that this happens. Well, maybe they didn't do that, but they must have done something, some of you might be thinking. Or doesn't everybody in prison say that they're innocent? Well, I used to struggle with some of these ideas as well. But then, in 1999, I learned about a case that really put me on the road to where I am today, to doing my life work. The case of the West Memphis 3 happened in a small Bible Belt town in the early 1990s, and it was at the tail end of something called the Satanic Panic Wave. And this was this sort of widespread belief at the time that certain criminal activity was actually motivated by satanic ritual abuse. And we got away from that idea. Law enforcement started to see that it wasn't actually happening, and just scholars kind of debunked it, and so that went away. But this was still very present at the time that this case happened. Now, 3 8-year-old boys were brutally murdered in the town of West Memphis, Arkansas. And despite the striking lack of evidence against them, 3 teenage boys from that town, Damian Eccles, Jason Baldwin, and Jesse Miskelly, were convicted in the crime. Now, 18-year-old Damian and 16-year-old Jason, they wore black clothes, They listened to Metallica. They made provocative art. And that description sounded a heck of a lot like me at the time, and they were right around my age. And the more I thought about this case and the more I researched it and looked into it, it really looked like these people, they were convicted based on their personalities, based on their appearance, but not based on anything that they had actually done. Now, this case moved me. Yes, it moved me emotionally, of course, but it also moved me intellectually away from any sense of confidence that I may have had in the infallibility of our criminal justice system. A wrongful conviction can literally happen to anyone. It may be hard to believe, but when you look at the cases of wrongful conviction, they are absolutely filled with cases of people with no prior criminal history, with no evidence connecting them to the crime, with an alibi, with no rational motive. These are fathers and mothers, and sometimes children, and veterans and police officers, and yet somehow they are convicted, and those convictions are upheld on appeal. So what is going on there? Well, that's the second lesson of the innocence movement. That what we have in the United States of America is not a system of truth. What we have is a system of fair procedure. It might sound like a fine distinction, but trust me, it matters. This is a reason that we call the juries the fact finders. We don't call them the truth finders. And a fact is a very particular thing under the law. So let's just imagine for a moment that you are being charged with a crime. You're on the stand, they put someone on the stand to testify against you, and that person gets up there and they just lie through their teeth. Everything that they're saying is false. Now, you do have something at your disposal, a constitutional right to cross-examination, and that is a procedural tool, and that is available to you. So what that means is that your defense attorney gets up there and they do everything they can in cross-examination to try to put holes in their testimony or to try to show that that person is lying. But at the end of the day, it is the jury who decides. And if they find that person credible, you're kind of done. Now, I did say that you could appeal, right? So if you get convicted, you can appeal. Yes, you can, but what you can't do, not really, is you can't really challenge the veracity of that testimony, not unless you have some sort of new evidence that proves that they were lying. That's a little bit crazy, right? I mean, I can really think of no worse system to getting at the truth than this process where a system sort of reconfirms its own mistaken findings, that it's not anticipating its own failure. So how do we get to this place in the courtroom? How do we get there in the first place? Well, that's the third lesson of the innocence movement. Now, certainly there are mistakes, unavoidable mistakes. People make mistakes, and some wrongful convictions are the result of that. But a tremendous number of wrongful convictions are the result of procedural aspects of our criminal justice system that are absolutely institutionalized. These are common features that we see all the time that we didn't realize until DNA cases started to come down, where we knew we got it wrong, that we started to see what kind of a problem this was. Now, I have a few examples for you. Eyewitnesses, for example, are notoriously bad, if you talk to the scientists, in picking out someone who was a stranger who they watched commit a crime or who committed a crime against the witness. And the scientists know this, and yet it seems so counterintuitive. We all think we know what we saw. And the testimony of someone in a courtroom saying, that's the person who did it, I'm 100% sure, well, that's beyond compelling. And this is what happened to our clients, Alan Northrop and Larry Davis. They both served over 17 years in prison for a sexual assault that DNA later proved that they didn't commit. Now, in this case, law enforcement had no leads. The rape was reported, and they didn't know where to start, and so they had the victim create a composite sketch. We've all heard of those, right? You've seen the sketch drawing, the pencil, and it doesn't generally even look like a human being most of the time. Yeah. Well, that was plastered all over the town. And one day, somebody at a bar said, hey, that kind of looks like Alan Northrop. And that is how Alan Northrop became a suspect in the crime. Now, Larry Davis was a friend of Alan's who was taller than he was with blonde hair. And that was all it took for Larry to become a suspect. Now, once they were on the radar, things kind of went downhill fast from there. They had their suspects, so they brought the victim in to do an ID procedure, and she didn't pick either one of them out. Now, some members of law enforcement in that situation might have said, maybe we don't have the right person, we should keep investigating somewhere else. In this case, they chose to just continue giving additional ID procedures to the victim, with the only photographs repeating being those of Larry and Alan. So eventually, she picks them out because she recognizes them, just not from the crime. She testified to this and they were convicted. 17 years lost. Now, confessions are sometimes false. This is a very difficult one for some of us to wrap our brains around. A lot of us might be thinking, I would never, ever say that I did some horrible crime that I didn't do. And a lot of us want to believe that. But fully 1/4 of DNA exonerations involved someone making a false confession or incriminating statement. I mean, those numbers are astounding. This happens. And people who are very young, or even not very young, but just maybe younger, and those who have lower intellectual capabilities, or those who are feeling a tremendous amount of pressure, absolutely fall victim to this. They're much more prone to do so. And this is what happened with our client, Ted Bradford. He's the one in the middle. His attorney's behind him. Now, Ted spent a decade in prison for a sexual assault that he didn't commit, that later was proved by DNA. And in his case, he was in the interrogation room, and it had been going on for a while, and two things had become clear. The first was that the law enforcement officers interrogating him had said, we have DNA from the crime scene. We're going to test it. We already have you, so you may as well cooperate now. And the second thing that became clear was that they were not going to let him out of that room. They were not taking no for an answer. And after 9 hours had passed, he made a decision. He thought, I'm not getting out of here unless I make this confession, this thing that they say is the truth. So I'm going to say that. And then they're going to test the DNA, and they're going to know it wasn't me, and this whole thing is going to get cleared up. So that's what he did. Now, the hitch in his plan was that the law enforcement officers had lied to him, as they are legally allowed to do. The U.S. Supreme Court has looked at this and said, sure, lying to suspects during an interrogation is a legitimate investigative practice. They can do that. But what they had lied about was the existence of testable DNA from the crime scene at the time. So this was in '93, and later we were able to exonerate him that way, but at the time the technology wasn't there. And so despite the fact that his statement had a tremendous number of inconsistencies between what he said and the facts of the crime, and the fact that he tried to recant it almost immediately after finding this out, that they weren't going to be letting him go, this confession was used against him and he was convicted. All told, 15 years lost. Now, snitches, I usually call them incentivized informants because I talk to legislators, but here I'm going to take a little artistic license and go ahead and call them snitches. They sometimes lie in order to get a deal for themselves. Some people may not realize that both law enforcement and prosecutors can incentivize people to participate in the process. And they can incentivize them in various ways, from straight cash payments to leniency or dismissal of their own charges. And those are pretty strong incentives. And this is what happened with our client, James Anderson. James was convicted of an armed robbery in Tacoma on the basis of statements by two people who got a tremendous amount of leniency in their own cases. Now, James had an alibi witness and had contended the entire time that he was in Los Angeles at the time that this crime happened. He spent 5 years in prison before we were able to bring documentation to show that he was in fact in Los Angeles, just where he said he was at the time that the crime happened. There are a lot of other causes of wrongful conviction, maybe not a lot, but there are a number of other wrongful conviction causes that have been identified through the cases of the innocence movement, and a lot of them hinge on sort of the fallibility of human judgment. Experts, so-called experts in some cases, will testify to conclusions about the evidence that are absolutely unsupported in science. Or law enforcement will develop tunnel vision on a particular suspect or a particular theory of the crime and fail to appreciate other evidence that's coming at them about the case. Prosecutors may fail to turn over evidence that is favorable to the defense, which is a requirement under the Constitution, or the defense lawyer may fail to provide effective assistance of counsel, which is required by the Constitution. Since nuclear DNA was first used to exonerate an innocent person in an American courtroom in 1989, 341 people have been exonerated. And if you look not just at the DNA cases, but the whole world of cases, that number leaps to almost 1,800. Now keep in mind, these numbers, they they represent this tiny fraction of all the criminal convictions out there that have been reanalyzed post-conviction. There's very few attorneys that work at all those innocence organizations that I just mentioned. In ours, we have a total of 2 full-time. Right? And so unless we were to undertake this wholesale reinvestigation of every criminal conviction out there, we have no way of knowing what these numbers actually are. We don't know what our error rate is in our criminal justice system. But what we do know is that the impact and the cost to all of us is tremendous. And this is the 4th lesson of the innocence movement. That the plight of the wrongly convicted is the plight of every single one of us, whether you're a prosecutor or a law enforcement officer or a member of the public or a crime victim. When our system fails on this epic scale, we all lose. We criminalize behavior in the first place because we want protection, because we want order, because we want justice for those who have suffered at the hands of others. And when we convict the wrong person for a crime, we don't get any of these things. On the spectrum of mistakes, a wrongful conviction is colossal. Every innocence case is one where the actual perpetrator was not identified, where they went free without being held to justice. But in 50% of the DNA exonerations nationally, half of them, the same evidence that was used to exonerate the innocent person implicated the actual perpetrator. And now we know what they were up to while the wrong person was serving their time. We know that they went on to commit at least 77 rapes, 34 murders, and 35 other serious violent felonies. And let's not forget, what about the victim in the underlying crime, in that first case where the wrongful conviction happened, for whom this system has failed entirely? And when someone finds out that the wrong person was convicted in their crime, they may have to relive that entire experience over again. Any sense of closure they may have had is now gone. And what's worse, they may have to endure a reinvestigation or maybe even a retrial. Now, I don't pretend to understand the plight of someone in this situation. But what I do know is that what we have here is not just your average run-of-the-mill mistake. What we have here is an absolute proliferation of harm. Now, I know this is getting heavy. But hope arrives with the 5th lesson from the innocence movement, and that is that system change is possible. We can take what we've learned from the innocence movement and do things differently. We can train law enforcement to do better eyewitness identification procedures that are based in scientific methods so that they are not so suggestive. We can record interrogations so that from the beginning to the end, so that if someone confesses, we can see what path they took to get there and decide for ourselves whether it's reliable. We could regulate the amount of testimony or the kind of testimony that we allow from someone who is being paid in one way or another for their testimony. Now, there are a lot of other things that we could do, and not all of that these sort of faults that we've learned about the criminal justice system that aren't exactly attached to innocence, but we've now started some of this work. So some progress is now underway. In 2013, my students and I were finally successful in passing a law to compensate the wrongly convicted in Washington state. It took a few years. And this is a vehicle, really, for people in this position to be able to get some sort of nominal amount for their immeasurable pain and suffering. But it also represents official recognition that these cases can and do happen in Washington state. And that is a critical first step toward a re-examination of the larger system that caused them. Just last year, we were successful in passing a law to preserve DNA collected from crime scenes. Because, you can't unlock the power of DNA if you throw it away. And this was a big problem in Washington state before last year. So although it's utterly clear that really irreplaceable evidence and valuable evidence has been thrown away, and there are people who will no doubt never be able to prove their actual innocence, with any luck, this law will be applied properly, and that evidence will be protected in future cases. Now, I want to let you in on a little secret. My students and I didn't have the success because we had some magic formula or because we had some special connections or anything like that. We really didn't. And we saw a problem, we articulated a solution, and we took it to the people with the power to change the law. And they did. The world truly is run and changed by the people who show up. So the sixth lesson of the Innocence movement is this. If you are moved by something, have the courage to put yourself in motion. Whether for you it's increasing STEM education in K-12 schools, or making art, or curing cancer, or solving the homelessness problem, or criminal justice reform. Take that feeling and translate it into some sort of tangible, positive social change. Because if you don't do it, it's entirely possible that no one else will. Thank you.